just want to start off with a point of some relevance. I'm just reading from the Companies House Register, a statement which has produced a lot of speculation around the place. This is from River Oak Strategic Partners. It says, one active person with significant control, Mr. Anthony Freudman of 50 Broadway, Westminster. Nature of control, 75% or more. And that statement has had a lot of publicity. It means, I suppose, that in theory I would like to fire George Yerrell, Niall Lawler, and that I'm actually secretly taking control of everything and become the kind of Donald Trump of Manston. The reality is somewhat different. So what I propose to do to clear the air once and for all is actually read from an exchange of emails with our solicitor. So it goes like this. We start with that, and I then write saying to our solicitor, Holly Gallagher, can you check this out? It may have been correct when the company was formed, but everything changed when the deal was concluded with our investors. She replies, Dear Tony, this is literally Friday. The persons of significant control information at Companies House only needs to be updated annually upon submission of the confirmation statement, which has replaced the old annual return. This is why you are still showing as the only person with significant control. You will recall that during the negotiations with Helix, the name is out there, so I have no problem in mentioning it, they told us that no person on their side of the transaction would qualify as a person of significant control, that's having more than 25%. Accordingly, the present position is that River Oak Strategic Partners has no persons of strategic control. We can, if you wish, file a new confirmation statement ahead of time, so this information is on the public record. Alternatively, we can leave the record as it stands for now, and it will be updated when we file the annual return in July. So I have replied to her, not surprisingly, thank you, Holly, can you please file a new confirmation statement now? Because it's being stated on social media that I control 75% of the company, and she replies, this is being done instantly. That's the explanation for that, and what I can tell you, and Sir Roger Dale referred to our investors when he gave his evidence on Thursday, that this is a company where no one person qualifies as a person of significant control as defined in the New Companies Act. So certainly not me. There is a consortium of people, their names are on the public record. We have 3 directors who are based in Zurich in Switzerland who represent very significant financial interests, which, of course, is another reason why we've been able to spend so liberally, but essentially on preparing the case that you all saw unfold last week. I felt it was important that we get that out on the record, and to be frank, we missed it. I mean, I didn't realise that once the deal was done, they wouldn't file an amended statement until July. I know now, some sharp-eyed person writing for one of the other less friendly sites, the mystery is solved. And if you look in the company's register on Monday, I think you'll find that it's all been put right. And just to say a little bit more about River Oak Strategic Partners, and again, you know, I know this is a place and a project that's full of conspiracy theories of all sorts. Some of them are probably justified, but in this case, not so much. We were faced with this situation. River Oak Inc. of Connecticut had funded and moved this project forward. We were being told that there ought to be a UK registered entity that was responsible, and we also knew that when we applied for the DCO and when we applied for the CAA licensing, we would need a UK registered entity. So when we went to the market last year to raise the funds that we needed, it was a precondition. We said to potential funders, this has all got to be done through a UK registered company. And our partners accepted that. What then happened was nothing particularly sinister. The creation of a new company, of which which there are 6 directors. Their names are out there. Niall Lawler, myself and George Yarrow are 3, and the other 3 are Nicholas Rothwell, Rico Seitz, and Gerhard Häusler, who represent the investment side, all very reputable Swiss people. As we created it, the issue arose about a link with the original River Oak. We were concerned with 2 things. We did not want to give the impression of something that was different from what it really was. So where we got to late last year was to the point where we said, this is a standalone British company. It has its shareholders and its directors. It isn't directly linked to the American government. We took the decision to do it that way, and the point was raised last week in the inquiry about George and Niall, and it's true, they're no longer directors of River Oak, Connecticut. Why? Because they are now focusing full-time on this project rather than anything else. Now that's not to say that there's no relationship anymore. George Yarrow will tell you, he still spends time at the River Oak office in Stanford. Relations are very cordial, and who knows where these things may lead. But for the moment, that's the position. No mystery, nothing sinister. River Oak Strategic Partners is the new company. We'll continue to call ourselves River Oak for short. We can be RSP as well, it doesn't really matter very much. We've made a full declaration to the Planning Inspectorate, and the application, when it's submitted in, hopefully, July, August, will be in the name of River Oak Strategic Partners. So that's, that out of the way, and, as it were, on the record. I'm sorry if anyone feels that they've been deceived or misled. I'm not sure what else we could have done about it. It's a perfectly normal and sound business approach to things, and it does mean that all our records now are filed in the UK, and insofar as the law requires it, anyone searching against us can find whatever they want to know about us, because the records will be there. Just wanted to say something about what happened this week, because it is important to us at a number of levels. I'm going to deal with it briefly with the legal side, but just to emphasise a point which will not go away about funding. We devoted enormous resources to this because this is so important for our case. We had to create the evidence base to show that the ABO report could not be relied. But there is a very strong case for the issue. We also had to create the right legal case. So when that case opened on Tuesday morning, we had a QC, a leading barrister, we had a junior barrister, we had an assistant barrister, we had 2 solicitors, we had a planning expert, we had 2 industry experts, as well as Mr. Yarrow. The other side had a barrister, a solicitor, and a planner. Also, all 3 directors of River Oak Strategic Partners were there. Niall couldn't be there for the last day, but the rest of us were there. No directors from the appellants were there at all, at any time. We felt that was important to show our commitment to the case and to be visible so that members of the public who were there could talk to us and see us. The case itself turns on some quite narrow issues, and what I felt I should do, actually, just to clarify things, is to read you briefly from these are the closing remarks, closing submissions by our QC. And some of you will have noticed also that our team actually was almost entirely a female team. Both barristers, both the leading barristers were women, and the solicitor was a woman, and the planning expert was a woman. And, in terms of gender equality, or whatever you want to call it, as far as I was concerned, we had the best people for the job, and my God, they did a fantastic job. And if I can just say this about our QC, Suzanne Holmes, is yay! What's the word? Forensic in her approach. And these days, relationship between clients and Queen's Counsel not quite what they used to be. They're not as deferential as they once were. You actually you can have a beauty parade, decide which one you want. And we decided to choose Suzanne. She had a reputation, but also we felt that when it came to cross-examining the only witness, as it happened from the other side, that she would do so in a way which was forensic, meticulous, but also courteous. We didn't want any of these old-fashioned, rhetorical throwaway lines, some of which you did see from their opponent. We wanted it to be done in a calm, professional, and courteous way, and it was done that way. And we were very pleased. Also, you will have noticed that the basic rules of evidence never change. You can give evidence about something you know about, or if you're an expert, you can give something about an area where you have an expertise. But if you're a planner, which is what they produce, you can't give evidence about the availability of property. You need an estate agent for that. You can't give evidence about why the airport failed in the past, if it did. You need an accountant or an economic analyst for that. If you stray outside the area, your own area of expertise, you're asking for trouble. And essentially that's what happened. And then to make matters worse, if when you're in your own area of expertise, you don't always get it right, it makes it even more difficult for you. So you have heard often enough this so-called policy EC4, which was the policy in the old saved local plan about the airports. I'm quoting to you, and again you should know this, how these things work these days. The case, the submissions, the evidence, the arguments finished at 4 o'clock on Thursday afternoon, maybe 4:15, something like that. There was then to be a site visit on Friday morning. Came on it. The council, for us, then had to go next on the Friday morning at 11:30. By 11:30, not only does she have to have her arguments marshalled, she actually has to have them typed up. So that by the time she started speaking, the document that I'm reading had been composed, checked, and put together. So I'm now reading you something which was finally finished at about 11 o'clock on Friday morning. That's how good they are. The whole document will be on our website before anyone suggests I'm quoting selectively. Because to read the whole thing, for those of you who are aware, will take an hour. Policy EC4 is concerned with land designated as an airside development area. This area is identified on the local plan proposals map, and it relates to all the land to the north of the runway and includes the land that the 4 buildings, the subject of these appeals, is located on. This land is specifically reserved for airside development, which is defined in paragraph 274 of the local plan, that's the existing local plan, as, quote, uses with an operational requirement for direct access to aircraft and therefore dependent on a location immediately adjacent to the runway or capable of direct access to it via taxiways. It was agreed by Mr. Alston, that's the other side's planning expert, that this policy applies to both temporary and permanent changes of use, and whether or not the airport is operational and that its purpose is to protect the integrity of the airport as an airport. It is agreed that these proposals, that's the appeal proposals, are contrary to policy EC4. Therefore, permission should be refused for these proposals unless there are material considerations that indicate otherwise. There is a dispute over the weight that should be applied to policy EC4. Mr. Alston suggests that some weight should be applied, whereas Ms. Shembry, our expert, suggests that full or significant weight should apply. And Ms. Ormsby submitted that the case for applying full weight to policy EC4 is convincing, unlike Mr. Alston's position, which is not. River Oak contend that whether EC4 attracts full weight depends on whether or not there is a reasonable prospect that the airport will be used for the purposes for which it was intended. Whilst Mr. Alston accepted that his original justification for the grant of planning permission for these appeals and his evidence to this inquiry were both predicated on that basis, he sought to row back from that position in his examination in chief, thus evidence to his own counsel. His evidence was muddled and confused on this. He seemed to accept that the issue of a reasonable prospect was relevant but not a key issue, and not a matter upon which the inspector needed to reach a view. We submit that ultimately he accepted that it was relevant, that it was a key issue, and that the inspector does need to reach a view on this issue. And even if he didn't agree, it's submitted that this is the correct approach. We say that at times Mr. Alston appeared to be confusing the two concepts of whether there is a reasonable prospect that the airport will be put back into airport use, and whether it can be conclusively stated that it will be put back into use. The first concept is its appeal. Is it reasonable? The second is not. The second is not relevant to the DCO either. However, we suggest that it is telling that the appellants, the other side, appear to draw away from the reasonable prospect test. We suggest that this is because it is incontrovertible on the evidence before this inquiry that the test is satisfied. We submit that the satisfaction of this test is not whether it is certain that the use will reactivate, nor whether it is likely that it will, only that there is a reasonable prospect that it will, namely a prospect that is not frivolous or theoretical. A possibility that it will is sufficient. That there is such a possibility was conceded by Mr. Casey's opening remarks. The reasonable prospect test, just to clarify this, emanates from the National Planning Policy Framework, paragraph 22 of which reads as follows. Planning policies should avoid the long-term protection of sites allocated for employment use where there is no reasonable prospect of a site being used for that purpose. Land allocations should be regularly reviewed where there is no reasonable prospect of a site being used for the allocated employment use. Applications for alternative uses of land or buildings should be treated on their merits. It's therefore necessary to consider whether there is a prospect that is real rather than frivolous that the airport may be used as an airport. It is submitted that it is untenable to suggest that there is not. It is also important to note that the reasonable prospect test is predicated upon the basis that the use or allocation is not currently operational or taking place, but is subject to a policy of protection, which is precisely the situation here. In other words, you protect a closed use because there's a reasonable prospect of it coming back into use. The fact that the airport is closed and vacant and has no aerodrome license merely reflects the circumstances that give rise to the application of the test in paragraph 22, which is concerned with policy protection of allocated land that is either vacant or not in use for the purpose for which it is allocated. It is not therefore possible for these reasons to be relevant as to whether the test is satisfied, as there are merely the circumstances that give rise to the test to start with. Mr. Alston accepted that, but then tried to suggest that they are nevertheless relevant. His evidence was inconsistent and confused. Just a couple more paragraphs and I'll finish. Moreover, and in any event, it is quite clear that the closure of the airport and stripping of its aviation equipment does not demonstrate that there is no reasonable prospect that it will not be used as an airport in the future. Anglo purchased the airport in 2013, stating that it represented, quote, a real potential for growth that has not been fully captured, and that the then owner was well placed to, quote, maximize opportunities for both freight and passengers advancement. However, after only 4 months, the airport was closed and then subsequently sold to another development company in which Anglo has an interest to develop the land for housing. No evidence has been put in the public domain, and certainly not presented to this inquiry, demonstrate that a financial appraisal was undertaken which showed that the airport was not viable or could not be made viable at the time it was closed. If such evidence exists, it is extremely surprising that it has never been produced. Mr. Alston accepted in cross-examination that his suggestions that the airport was not viable or could not be made viable at the time of its closure are merely unevidenced assertions. Those assertions are directly contradicted by the unchallenged substantive evidence of 3 experts of this inquiry. That's from our side, Mr. Kane, Dr. Dixon and George Gerald. They are directly contradicted by the unchallenged substantive evidence of 3 experts of this inquiry that the airport can be made to be successful, which is wholly consistent with Mrs. Gloag's statement at the time she purchased it. It is quite clear, therefore, that the reasonable prospect test is satisfied. And finally, moreover, the fact that the owner has no intention of selling the site is neither here nor there. As Mr. Alston rightly accepted in cross-examination, the planning system is not there to serve private interests or aspirations, and compulsory purchase powers exist to get around an unwilling seller. The planning system does not allow the truculence of owners to dictate how land should be used. No weight can be ascribed to this intention. In addition, Mr. Alston accepted that his reliance on the fact that 2 previous owners had not managed to make a success of the airport did not include any analysis or explanation of the specific reasons as to why those owners had failed, nor any analysis of the specific reasons for that failure or whether they need to be repeated. This is in stark contrast to River Oak's unchallenged evidence that there were specific reasons why past owners had failed and that those reasons need not be repeated in the future. In light of this, no weight can be ascribed to the past failures of previous owners in considering whether there is a reasonable prospect that the airport can return to airport use. There's a lot more, but essentially, that's the core of the case. It doesn't do to be too confident or too cocky about these things. We don't know what the result is going to be. I think from our side, we feel we could not have done more to advance the case. Hours and hours and days were spent in preparing it, and I think for those of you who were present, you will have noted just how much effort went into it. For anyone who ever judges or questions our commitment to the project, you should really think about what went into that. It was a truly just quickly, where do we go from here? The position now is this. We are conducting what's called a land referencing exercise. We have to notify anyone with property within a certain distance of the airport that we are planning things on the airport which could result in noise, both aircraft noise, but also in the short run vehicle noise from vehicles going on and off the airport with carrying materials and so on. That process has started. We've also, some of you will have seen this, we've sent out a statement of community consultation, which is basically a statement of how we intend to consult with the community. The period for responses to that is now finished. We've had responses from a number of statutory authorities, including Thanet, some of whose responses were quite sensible.
A small minority, I would think.
But also from Dover and from Kent, from KCC and so on. And we'll incorporate some of those responses in the final document, which simply then spells out exactly how we're going to consult. We then have to, now we've had site access, we have to complete another document which is called a PEER, a Preliminary Environmental Impact Report, which sets out every aspect of the environmental impact of what we're proposing, and that in turn will include noise studies, detailed noise studies. All of that work will be published and will form the major part of a series of statutory consultations which will start probably now in May. We'd hope to get it done in April, but of course Easter falls in the middle of April. The advice we've had is that you shouldn't, people are away at Easter and so on. So it looks as though statutory consultations will start perhaps in the last week of April and then run through into May, maybe into early June. They will be similar in format to the ones that we had last July, a little bit more formal this time, a lot more material available because you will see the full master plan, you will see the noise modelling, there will be and of course there will be a lot more environmental information because you have access to the site. The consultation will run for a period, let's say until the end of June. There will be events at various centres, repeating more or less what we did last year with a few additional ones. And we've also had a request to, if not a full presentation, then certainly an event at various parish council, parish halls around the area, which we will do, of course. Once the consultation is complete, we then, and sorry, I should say, while that's going on, the statutory agencies, that's the Environment Agency, Natural England, and all the other bodies, they have a right to comment on the proposals as well. We then have to incorporate all those responses into our final document, which is then submitted as part of the development consent order application to the planning inspectorate. We, again, not sure exactly what the timing will be. We'd like to think we could get it done in July. It's difficult because we don't know quite the volume of responses and what their substance will be. Again, we're being told it's considered not quite acceptable to put these things in August. So if we miss the end of July, we'll probably have to wait until the beginning of September. The planning inspector then has 1 month in which to accept the application, and the system is such that it's designed to ensure that there's been a dialogue with the planning inspectorate in the build-up to the process, which means that there will be, they have to be careful not to express an opinion, but they're aware of what's going to go into the document. So, it's, in other words, in situations like this, it's very unlikely that the application will not be accepted. But then is a further process. They then appoint an inspector who doesn't have to conduct a public inquiry like the one that we just saw last week, but will hold a series of hearings to test specific issues, to give people a chance to be heard, whether it's no night flights or any other issues that arise. But it's not in the form of a public inquiry, so there won't be barristers and solicitors involved. It's simply the inspector announcing that he or she is going to be available on a certain day to cover a certain topic and inviting people to make submissions and go and talk. That process can take anything up to another 12 months. We don't know at the moment. So it means that we believe that we're heading for a confirmed development consent order and, of course, a compulsory purchase order sometime towards, let's say, the autumn of 2018. That's roughly where we are. We have accelerated the process since gaining site access. We haven't quite made it for the time we lost last year, but we have speeded things up, which is gratifying. Lots of documents were filed last week. All our work is in front of the inspectorate. We are going to put it all out in the public domain. There's a huge volume of it. We are currently wrestling with how to get it out there in a form that is easily accessible, because there are literally hundreds of pages of material. So without wanting to be accused of misleading anyone, we are trying to put together executive summaries and cut down versions of the salient points. There is a further document which will appear in the next month, which covers the, to use the jargon, the socio-economic impact of the airport, which is basically jobs, training and education. That work is about half finished. It should be out there, I would guess, around Easter time. as soon as it's available, we'll publish that as well. And that's really where we are. I just want to say also that you saw some of them last week. For me, it's been a privilege actually working with such a good professional team. We worked very hard to make sure that we hired the right people. We wanted not just top quality professionals, but also people who were capable of working together as a team. I think we've achieved that. They've been together now for, well, since January of last year, so it's it's getting on to 16 months, something like that. And they will be together until this project is finished. The other thing that, of course, is happening, there's a sort of crossover between what we're doing and the wider world, in the sense that government policy and government attitudes towards air freight in particular have changed dramatically since the Brexit vote, and this change is gaining in traction very rapidly, because I think it's dawned on people that if the UK is going to improve its trading relationships with far-flung countries, it has to be done via cargo links, which have to be done from an airport like Mansfield. There is no other capacity to do it. We have, working with Sir Roger, an event on Tuesday, a breakfast meeting in the House of Commons with a number of key parliamentarians and government advisors and so on, including the Transport Select Committee, to bring them up to date on what we're doing and show them how the Mansfield project connects with the bigger picture, which is important. And that work will continue. There will be more events later in the year. With a new website, which some of you will have seen, we're trying to make it as relevant and informative and as interesting as possible. What I should say, I think, is that we will continue to resist the temptation to rise to various baits that are thrown out. And I think tempting though it is at times, I mean, it really is, but our function, we've investors, we've responsibility to our investors and also to the potential customers that come here. And the last thing you want is for them to check up on you and for them to find out that you've been in a sort of an unseemly slanging match with a local politician or with somebody who writes on social media. So we won't do that. And if that disappoints some people, then I'm sorry. And just finally, this is unusual, I never thought I'd find myself doing this. One of our legal team, I remember these people had spent, they were here the week before last, for a site visit to get to know the area. They spent all last week here. We were all together for a week. During that time, you interact with other people, you talk to other people, you meet other people. And one of them yesterday actually wrote a poem, which I never thought I'd find myself reading out a poem written by a lawyer. And here we go. So this is what she wrote. A place where people sit in the pub, talking about waiting for the yellow stickers in Morrison's, where need wheedles for change in the street, Christmas lights in March, Woolworths still boarded, and cleaners dream of a job answering phones. A place where hope has remained, where lives must go on, babies grow, men must still provide, must dream. This is a place of defiance, where gentle sarcasm and biting cynicism tell the world at large that we still live, still hope.
Sorry about the sun.
Two questions that I think you can clear up very easily. One was in response to the things that we've heard from others, and responded to the question of have Kings had notice of the formation of RSP?
Yes.
I knew that the answer, but I thought that that's to have it out there. And secondly, on the difference between the map that showed the area of consultation, that was in the draft SOCC, and the noise profiles over Ramsgate, which some people have suggested, people with a malignant personality, shall we say, have suggested that you're deliberately trying to exclude the people of Ramsgate from any environmental assessments.
Right, yeah, it's a very good question. Look, there's a confusion of two issues. There are two levels of consultation. I mean, first of all, the whole of Thanet will be consulted generally on noise impact. But there is a specific requirement for those properties where the noise level could exceed 63 decibels, which is the measure. That's the reason for the smaller number. But it doesn't mean that the whole of Ramsgate won't be consulted. It's just that on our experts' advice, they fall outside they're below the 63 decibel level. They may be 54, 55, 56 decibels, but not 63.
Yeah.
That's the answer. There are two separate tests, and I'm not saying it's easy, because it isn't. The 63 decibel test relates to potential impairment of property values, whereas the 54 decibel and above test relates to disturbance to your life. They're two separate things. So we say, I mean, we're going to consider the responses we've had to the we've actually got a technical meeting tomorrow to go through it. But that in simple terms is the reason for the apparent discrepancy.
No. With all the money what Red River has spent now, what happens if Chris Wells does find this other investor what he keeps going on about?
Well, let's try and state a certain fact. This airport will not be viable if it isn't a big airport. If it's a big airport, it's a DCO. It has to be a DCO. It can't be anything else. Section 160 of the Planning Act 2008 actually makes it a criminal offence to try and circumvent the DCO legislation by going to the CPO when you're not allowed to. So, in theory, Mr. Toole could come along and say, I'm going to run a small airport there. I'm not going to put all the investment in that we are suggesting. I'm not looking for anything like 10,000 cargo movements. And I'm going to do a CPO with Thanet and enter into an indemnity agreement. Our response to that would be to say, well, that doesn't make much sense. But from Thanet's point of view, if you're taking on a partner, because they would be a partner, for a CPO who appears to be working on a plan that's not viable, that can't be very sensible for the local authority, because that would involve risk. That's the first point. The second point is that if they did that, they would have to then reverse their draft local plan, in which they say that the airport is not viable, and change their position completely. We just can't see how that's possible. And then finally, the process by which Thanet Council and Mr. Trule's people would enter into and agree an indemnity partnership. Remember, we know something about this. It's likely to take so long and be so protracted, the DCO will probably have gone through by then. And what you have to remember is that Thanet has no legal or financial interest in the airport. The airport belongs to who it belongs to. What did they say last week? We are not going to reopen it as an airport. It's going to be housing. So somebody is going to have to take it away from them. We say the only lawful way of doing it now is through the DCO process.
Thank you.
very unusual terms of planning fees. Normally, TDC would make a decision and the applicant would appeal against it. In this case, as the appeal was prompted by TDC's refusal to grant possession, either by non-determination of refusal. Now, TDC refused or failed to put any evidence to support their original decision. And in the normal course of events, if the appeal, the planning council's position was changed on appeal, the cost would be awarded so that TDC would pick up the costs. In fact, that guidance is given to councils when they're determining appeals, determining initial decision. In this instance, planning council's failure to back up their original decision and the fact that you, in effect, have had to pick up their case in a way by opposing SHP's appeal poses an interesting question as regards how costs should be allocated. Now, I don't know whether you've had any discussions, maybe you don't want to discuss it at this stage of the time, except, but how do you feel costs should equitably be distributed? How much should they fall on planning district council? Whichever way the appeal goes, I mean, I accept it could be a hybrid decision with some goods being granted and not others, but I don't think that's unlikely.
The advice we've had, I don't want to say too much, is that the inspector has the power to order costs if he takes the view that one party has behaved unreasonably. It's all about behaving unreasonably. It's unusual to order costs at the end of an inquiry, unless he says that a party's behaved unreasonably. Costs are often ordered if one party withdraws, but not otherwise. So I don't want to say any more than that. And of course, as you know, the reason that the discussion that took place about the council's change of position took place in private, so nobody knows what was said.